How FAA enforcement against airmen actually works. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with the first and most important point about FAA enforcement against airmen. Not every FAA problem begins as punishment, but every serious FAA case begins with proof. The governing framework starts with 14 CFR Part 13, FAA Order 2150.3C, and the FAA's compliance program. That structure matters because the FAA does not just have one enforcement tool, it actually has several. In practical terms, the agency works in three gears. The first gear is compliance action. The second is administrative action, such as a warning notice or a letter of correction. The third is legal enforcement, which can mean certificate suspension, revocation, or in some situations, a civil penalty. This is one of the biggest misunderstandings in this area. Pilots often think the FAA either does nothing or takes your certificates. The real system is more graduated than that, but it is also less forgiving than many airmen assume. The FAA's own compliance program explains that the agency prefers rapid compliance and corrective action when the event reflects a mistake that can be fixed through cooperation, root cause analysis, and a durable correction. That is the modern compliance model. But the same FAA order also says that there are categories that generally require referral for legal enforcement action. Those categories include intentional conduct, reckless conduct, matters involving qualification or competency, and conduct where legal enforcement is required by law. That distinction is critical. If the FAA sees an honest, low-risk error and a cooperative airman, the matter may stay in the corrective lane. If the FAA sees dishonesty, recklessness, substance issues, repeated noncompliance, or true qualification problems, it can move quickly into the punitive lane. So remember this. The FAA is often willing to forgive a mistake, but is rarely willing to forgive a cover-up. There's another confusion point here. Airmen often use the phrase enforcement action to describe every unpleasant interaction with the FAA. Legally, that's not accurate. A re-examination under 49 U.S.C. Section 44709, often called a 709 ride, it's not the same thing as a punitive punishment or a suspension. It's remedial, and it's aimed at competency. But from the airman's perspective, it can feel just as consequential because it directly puts qualifications at issue. That is why qualification issues deserve special attention. Under Order 21503C, if the event suggests the airman may not have the knowledge, skill, judgment, or responsibility required to hold a certificate, the case can move out of the ordinary compliance track and into re-examination or certificate action. Once the FAA chooses legal enforcement, procedures become everything. Under the Pilot's Bill of Rights, the airman is entitled to written notice of investigation to cover certificate matters. Under the NTSB rules, appeals from the FAA suspension or revocation order generally must be filed within 20 days, and emergency appeals move even faster. That deadline is not a technical footnote, it is often outcome determinative. The NTSB explains that a late appeal can be dismissed, and a late answer can lead to facts being deemed admitted. In other words, some airmen lose procedurally before they even lose on the merits. Another practical reality is that evidence in these cases is often ordinary and unglamorous. FAA investigations are built from air traffic control audio, ADS-B data, radar tracks, maintenance records, training records, medical applications, text messages, and statements made by the airmen. The case is frequently won or lost on small documents created before anyone thought there would be legal enforcement. That is why the first response to the FAA inquiry matters so much. There's the impulse to explain everything immediately, and that can be dangerous. You do not need to help an FAA investigation by guessing, speculating, or trying to be overly reassuring. Precision is much more important than speed. In short, FAA enforcement exists against airmen, and it's best understood as a decision tree. The FAA asks whether the event reflects a fixable mistake, a pattern, a qualification problem, or a character problem. And once the agency decides which one it believes it has, the rest of the case usually follows. Would like you to take this away, and I hope this sticks. The most important moment in an airman enforcement case is often the moment before the airman realizes the case has started. When most airman enforcement cases arise in practice. Now let's turn to the second major issue, where airman enforcement cases most commonly arise in the real world. It's important to be careful here because the FAA does not publish a simple single table that says all airman legal enforcement actions break down into neat percentages by allegation, per se. But based on the FAA's guidance, the categories in order 2150.3C and the recurring body of published NTSB airman decisions, the same clusters of enforcement actions appear again and again. The first cluster is pilot deviations that are visible to air traffic control or otherwise easy to reconstruct after the fact. And this means altitude deviations, airspace incursions, failure to comply with clearances or instructions, runway incursions, and related careless or reckless charges under Section 91.13 is especially important because the FAA's catch-all risk rule is often charged residually with another operational violation. A busted clearance may become a Section 91.123 case, but it often arrives with Section 91.13 attached because the FAA frames the deviation as creating actual or potential endangerment. A published example is Leaschauer. In this case, the NTSB affirmed a 155-day suspension after the pilot entered into San Francisco Class B airspace area without clearance and did so without holding a valid medical certificate. The board also sustained the Section 91.13 charge because the operation created potential hazard to others. That example is useful because it shows how these cases really work. One event rarely produces only one count. A single flight can trigger an airspace violation, a qualifications violation, and a careless or reckless allegation all at once. The FAA loves to assert careless and reckless. It's almost always included. The second recurring cluster is record-based enforcement. These are cases built not from what FAA air traffic control saw or heard, but what the airman signed, logged, endorsed, or omitted. This is where intentional falsification becomes existential. Under 14 CFR Section 61.59 and in medical cases Section 67.403, the FAA and the board treats intentional falsification. It's a fundamentally integrity offense. The case Hart versus McLusis asks whether there was a false representation, whether a concern the material fact and whether the airman knew it was false. The consequences here are severe for a reason. The FAA regulatory system depends on truthful records. If the agency cannot trust the logbook endorsements, the medical application, the training sign-off, or the test application, it sees the problem not as a paperwork issue, but as a qualification and judgment issue. A strong example is the board's decision in Jones, where the NTSB explained that the Hart-McLucas test governs intentional falsification cases. Another is the board's decision reported at order number EA-5490, where a false flight crew endorsement supported revocation because of intentional falsification. And intentional falsification is treated as grounds for revocation. Remember this point. In FAA enforcement, a bad landing may be survivable, but a bad record can be disqualifying. The third recurring cluster is medical and alcohol-related matters. These cases are often misunderstood because some begin on the ground and not in the aircraft. Under Section 61.15, an airman must report each qualifying motor vehicle action involving alcohol or drugs within 60 days. The FAA separately treats multiple motor vehicle actions within 3 years as a certification issue. And under Section 91.17, acting or attempting to act as a crew member while under the influence of alcohol or with a prohibited blood alcohol concentration can lead to severe certificate consequences. That means a DUI event can become several different aviation problems at once: a motor vehicle action reporting issue, a medical certification issue, a judgment issue, and sometimes a direct operational issue if flight activity is involved. Airmen get into trouble when they think the driving matters only belong in traffic court. The fourth recurring cluster is qualification drift. This is an airman who flies without the required medical, without current qualification, without proper endorsement, or beyond the privileges of the certification held. These cases can look minor from the cockpit and major from a regulator's desk because they go directly to whether the pilot was legally entitled to act at all. There is also an important lesson in the old Brasher line of cases. Pilots sometimes believe that if air traffic control does not immediately advise them of a possible pilot deviation, the FAA case disappears. That's wrong. The board has made clear that immediate deviation notice rules are limited, and lack of notice is not a universal defense. So where do most meaningful airman enforcement matters arise? In my view, supported by published authorities, they arise when the government can prove the case from objective data, radar, audio, records, applications, endorsements, and other official reports. That is why operational deviations and falsifications show up so often. They are provable. The bottom line is simple. Most airmen do not face serious FAA trouble because they set out to violate the rules. They face it because one deviation created data, one form contained a bad answer, or one effort to smooth over the facts turned a manageable event into a certification case. I'd like you to take this away. The FAA's strongest case against airmen usually begins when the facts are recorded before the defense is even written. Before you respond to the FAA, you should stop, think, and then respond. Defending, mitigating, and avoiding the case you never thought you had. Finally, let's discuss the issue that matters most after the phone rings. The letter arrives or the inspector asks for a conversation. How should an airman respond, and how good cases are prevented before they even exist? The first principle is to separate safety response from legal response. If there has been an operational event, and address safety immediately. Secure the aircraft, preserve the records, protect the data, and document what happened. But do not confuse that with volunteering a polished narrative before the facts are known. In these cases, the chronology is power. Save the flight track data, dispatch notes, screenshots, maintenance records, text messages, training records, and medical correspondence. If the later case turns into what an airman knew and when the airman knew it, contemporaneous records will matter far more than reconstructed memory. The second principle is to understand the difference between cooperation and self-inflicted damage. FAA inspectors begin with what looks like an informal discussion. Sometimes it's informal. Sometimes it is the front edge of an evidentiary file. You should be respectful and you should be professional, but also be careful, accurate, and deliberate. The third principle is to recognize when the case may still be steered towards correction rather than sanction. The FAA's compliance program, it does reward candor, responsibility, and meaningful correction action in the right kind of case. If the event was inadvertent, isolated, low risk, and honestly reported, early correction framing can matter. But there are hard limits. Compliance action is generally not the right answer where the FAA sees intentional conduct, reckless conduct, falsification, substance-related issues, or a true qualification problem. In those categories, the airman should assume the case may move into formal enforcement territory quickly. A related protective tool is the Aviation Safety Reporting Program under Section 91.25. The FAA generally may not use reports submitted to NASA under the ASRS for enforcement purposes, except in excluded categories such as accidents or criminal offenses. Advisory Circular 00-46F and NASA's published caveats also explain any waiver of sanction is limited. The event must be inadvertent, timely reported, and not otherwise disqualifying. This means that the ASRS is important, but it's not magic. It can be a shield in the right case. It's not a pardon for intentional misconduct, accidents, criminal conduct, or qualifications fraud. Another misunderstood point involves emergency orders. When the FAA believes safety requires immediate action, it can issue an emergency suspension or revocation. That accelerates everything. The NTSB's deadlines shorten, and the pressure on the certificate holder increases immediately. These are not cases to drift through casually. There's also a strategic lesson from falsification cases. In operational cases, sanctions may sometimes be mitigated. In intentional falsification cases, mitigation is much harder because the FAA and board treat dishonesty as evidence that the certificate holder cannot be trusted within a system built on trust. That is why the defense objective in those cases is often not sanction reduction. It is defeating the intent element itself if the facts support that defense. For mechanics and instructors, the same logic applies. An enforcement case is not only about whether a flight was safe, it may be about whether an endorsement, return to service entry, or application statement was true. The record you create on the ground may carry more legal weight than the flight you performed in the air. A boardroom quality prevention strategy for airmen, therefore, has 5 parts. Know the privilege you're exercising. Know the currency and qualifications rule that apply. Answer every FAA form as if it will be litigated. Report when reporting is required, and never improve a fact after the event. This last point is one that I'd like you to remember. Many airmen survive the deviation. They do not survive the explanation. A final practical example makes this point stick. A pilot busts a clearance, files a prompt ARS report, preserves the data, avoids speculation, obtains counsel before responding in writing. That pilot may still face scrutiny, but the event remains an operational case. By contrast, a pilot who backfills a logbook, changes a training entry, gives a confident but inaccurate statement may transform the same matter into a character case. Here's the memorable point. FAA enforcement becomes dangerous when a flying problem turns into a truth problem. In short, airman enforcement is misunderstood because many pilots focus on whether the flight felt safe, whether the FAA focuses on whether conduct was compliant, provable, and trustworthy. These are not always the same question. Here is the takeaway line. In an FAA case, the best defense usually begins long before the investigation, with disciplined flying, disciplined records, and a disciplined response. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Please direct questions, and they are certainly welcome, to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.